it's a pleasure and an honour to introduce Jenny Beck, who is an award-winning KC and co-founder of Beck Fitzgerald. Jenny is known for her deep commitment to fairness and accessible justice. Her work focuses on supporting families through some of the most complex and challenging moments, with her particular expertise in cases involving domestic abuse and its impact on children. Thank you so much, Jenny, for joining us live from London. Over to you.
Fantastic. Okay, lovely. Okay, well, firstly, I'd like to thank Emily and Kate for inviting me to speak today. I'm just sorry not to be able to be with you in person afternoon, and in spite of the description somebody gave me in your packs as a powerhouse, that pesky space-time continuum continues to defeat me, and I won't be able to get to Sheffield and back in spite of the lovely sunny weather you're having in the time frame. I'm especially saddened not to be in the room, because it would be great to speak to everybody. But I hope you'll ask questions and enjoy a day of learning and debate as we collectively explore how we can better hear, support and protect children and families that we serve. I've been a family law solicitor specialising in domestic abuse and complex cases concerning children for over 30 years. I run a specialist practice, which is a little bit different because we combine representing clients on the one hand with trying to campaign for systemic change to make our system better for the children and families that pass through it. In addition, I sit as the private law representative on the Family Justice Council, which is a multidisciplinary council chaired by the president of the Family Division and charged with monitoring our system. And that gives me a kind of bird's eye view of the family justice system from the differing perspectives of all of its stakeholders. I also chair the Nuffield Family Justice Observatory. This is a unique but critical organisation which uses research-based evidence to identify challenges within the system. It excels at reimagining solutions, some of which I want to talk about a little bit today. So those different roles give me a real insight into the system and its operation. I want to share some of my observations about the way our family justice system understands and responds to complex issues, and particularly where I see its critical failure to properly identify and manage domestic abuse and its impact on families and children. I also want to start a conversation about a reimagined system built to accommodate users' lived experience, and I think that needs to start with a shared vision. I just want to say that in spite of talking about those organisations, the opinions I'm going to give today are my own. So over the last 30 years, I've seen considerable change, but what worries me is not that which has changed, but that which has not. You've heard some statistics about domestic abuse already from Haven. Of course, it's a crime and a killer, and successive governments have pledged to address it, reduce it, or even eliminate it. Yet the statistics remind us that those promises have failed. 2 women a week are still killed by a violent partner or ex-partner. Prevalence data underestimates the problem and masks its gendered nature. We see daily reports of horrific acts of abuse in the domestic sphere, which is still minimised and normalised. We have poor data, and only in 2021 did we actually have a statutory definition of domestic abuse, which captured the highly dangerous behaviours of coercive control and economic abuse. And I was listening intently to Haven when they talked about just how that underlies all abusive behaviours, just how important it is for us to properly, as a society, understand the huge danger that associates with coercive and controlling behaviour. Domestic Abuse Commissioner's 2025 report, Everyday Business, reveals that domestic abuse is present in nearly 90% of private family law cases concerning children. And yet our current system fails to respond safely to it. It regularly minimises allegations, and it often re-traumatises survivors. I'd like to advocate a renewed effort to drive change by breaking down the silos under which we all work and promoting a more holistic way of working together to gather a better understanding of the lived experience of system users. A shared vision, if you will, of a system which better hears and protects those it serves and has priorities that we can all get behind. So this reimagined system should have some central priorities: helping children and families to thrive, enabling children and families to participate in the vital decisions we make about their lives, and a system which treats people fairly and with equity. That doesn't actually sound like too much of an ask, nor do I suspect anybody here would disagree with that as a shared vision. Sadly, however, we have much to do. I think the first thing we need to accept is that our family justice system is not, in fact, a system at all. It's a series of silos operating with different drivers, a lack of a shared vision, or even a common language. And this fragmentation undermines effective collaboration and results in a system that fails complex and intersectional issues. Moreover, it's a system itself in trauma. Underinvestment, work overload, chaos, and burnout have become the norm for practitioners across all the silos that make up our system. It's a fragile system, and fragile systems are rarely equipped to deal with complexity. The resulting chaos disproportionately impacts survivors of abuse and children growing up in households characterised by high conflict and abuse. Indeed, to adopt the foundational ethical principle from the NHS, do no harm, I'd venture to argue that the current operation of the system itself is actually capable of compounding harm. These failures can't be ignored. We need to stand back from our system and our individual silos to identify the challenges and collectively champion better practice. In my short talk, I'd like to address some of the main barriers to justice that I see and start a conversation about a system which might properly address them. A system which flips its lens to properly capture lived experience and hear the voices of the children and families who use the system, rather than focusing, as we often do, on the operational players in the system and the challenges that they have. So slide 3, please. So what do the challenges look like? Well, I'm just going to focus on a few because otherwise I'd have you here all day. And I'm sure you have other interesting people to hear from later on. So the ones I want to talk about are unequal access to justice, the fact that we have an adversarial approach which polarises parents and silences survivors and children, the lack of transparency, consistency and accountability in our system, and the ineffective mechanisms we have to hear children's voices. Now, against those challenges, all of which are systemic, survivors of domestic abuse and their children experience even greater difficulties. They're more likely to be experiencing trauma and need additional protection to ensure their rights are upheld. Yet these challenges disproportionately impact them. Let's explore them in a bit more detail just to illustrate the point. So, unequal access to justice was the first issue I raised. Unequal access to justice disproportionately impacts survivors of abuse and their children. It's resulted from years of underfunding and a lack of prioritisation of basic legal advice. Most of you, if not all of you, will have heard of the destruction of any functional legal aid system, which resulted in 80% of parents now entering proceedings without legal representation, often navigating complex processes at times of significant emotional distress and without support. Moreover, prohibitive bureaucracy, including gateway and unnecessary means tests, mean that survivors of domestic abuse are often denied representation. But this isn't the only problem. Derisory rates of pay have resulted in practitioners being forced to leave legally aided work. So even where survivors are eligible for legal aid, they find it increasingly difficult to find a solicitor who's able to take their case on. Many report calling dozens of lawyers before finding anybody with capacity to help. Those with complex needs, who have language barriers or additional communication needs, find getting help even harder under legal aid, as their cases are going to require more time against the backdrop of a fixed fee regime. Representation in court is the next hurdle, with private cases, i.e. cases where people pay privately, commanding fees 10 times greater than can be secured under legal aid. So that means that all but very junior barristers won't really represent legally aided clients. Yet these are the most complicated cases, evidencing abuse, particularly the most harmful coercive and controlling behaviour, and its impact on children, against a pro-contact culture, takes expertise and experience. So we're in this bind that the junior end of the bar has the least experience, and yet these cases are often the most complex. But once you get to the experienced end of the bar, nobody wants to actually take them for the fees that are being offered. So an uneven playing field emerges. We all know that domestic abuse is a gendered crime, disproportionately impacting women. Gender pay differences means that men are more often able to afford expensive and experienced barristers, leading to an inequality of arms, which of course undermines justice. Where alleged perpetrators can't afford representation, the situation is no better. Even when they have no means, they won't satisfy the test for legal aid unless they can also prove they're a victim. That's unjust, because you do need equality of arms if you're going to have an adversarial system. But it also encourages a new route for post-separation abuse via the actual court process itself, the process which is supposed to be keeping survivors and their families safe. It brings me back to the do no harm concept. It's commonplace to find unrepresented parties forced into a polarised situation from the outset. Many use the actual process itself to abuse, and the system actually lets them. The removal of legal aid for alleged perpetrators now means that survivors often face their abuser without the buffer of a lawyer. In a desperate attempt to maintain fairness between a represented and an unrepresented party, judges accommodate all sorts of breaches of the rules, late filing, excessive paperwork, all of which can be manipulated to undermine a traumatised survivor from achieving their best evidence. In short, the impact of cuts to legal aid and the lack of commitment to a workable system has dealt survivors and their children a real blow. It's made an already fragile system even more dangerous and unfair. The second challenge I want to talk about is our adversarial system. So our entire court system is built on an adversarial model, which effectively polarises parents, silences survivors of abuse, fails to effectively problem solve, and is not trauma-informed. Indeed, it often re-traumatises survivors as a result of the way it operates. Again, survivor victims are clearly the most impacted because the system hobbles their opportunity to achieve best evidence within the adversarial system. Well, why is this? It's because domestic abuse survivors are usually in trauma, yet our processes are not trauma-informed. We expect evidence to be clear and corroborated. We expect witnesses to forensically dive into their memory to confirm dates, times, facts and feelings which support exactly what they're trying to evidence. Yet we know that the impact of trauma on the brain is to shut down the very part that acts as the filing cabinet of facts and dates, the exact part survivors need to access to prove what's happened to them. We know the courts need to be trauma-informed, to be fair, and yet they aren't. I've actually been in court and had a judge say to me, well, I don't find your client very credible because she can't remember which day she was raped on. Well, of course she won't remember because the fact of the date was irrelevant at the time as her system went into overdrive to actually survive. So in order for domestic abuse to be considered relevant in proceedings concerning children, it has to be proven as a fact. And yet, as we've seen, proving those facts is much harder if you're in trauma within a system that's not trauma-informed. The onus is on the person alleging the abuse, so the stakes are high. But as we've identified, our underfunded adversarial system mitigates against the sort of time and support needed to explore evidence and recognise the impact of abuse on children and families. Moreover, if somebody fails to prove abuse, in the eyes of the court process, the abuse actually hasn't happened. Our binary system says that unless you have a finding of abuse, which may have been failed to have been proven for any number of reasons, that abuse simply hasn't happened. And the way the process will now treat the family is as if there isn't any abuse. Here, the minimisation of abuse and the failure to understand and uncover more nuanced forms of abuse becomes a major issue. The debate between whether something is a high conflict situation or abuse rages on. But the failure to have a properly inquisitorial system which flushes out dangerous behaviour actually compounds the problem by misunderstanding or minimising behaviours such as coercive control. Coercive and controlling behaviour is particularly hard to prove because corroborative evidence is hard to secure. This explains why findings are hard to achieve and prosecution rates for this highly dangerous crime are woefully low. In short, therefore, we have a system which minimises abuse and its impact on survivors and children, which undermines a supportive framework, which would allow best evidence, which permits the silencing of survivors and children by allowing abusive litigation, and which fails to provide a safe mechanism to expose more nuanced but no less dangerous forms of abuse, like coercive and controlling behaviour and economic abuse, which of course keeps so many people in those dangerous relationships. Next slide, please. So many of the above issues were highlighted in the harm review, which is now 5 years old. Systemic change was advocated and the Domestic Abuse Commissioner's Office was charged with monitoring the system. Their report, which you can see on the slide, which was based on the research of Professor Mandy Burton and Professor Rosemary Hunter KC from Loughborough University, reveals that 90% of all cases coming to court feature domestic abuse. If these cases aren't allowing true harm to be effectively managed, then we don't have a workable system. There are, however, some green shoots. I hate to be entirely negative. Important work is being done to better understand conflict and abuse. And I know you're going to be hearing some important research findings today about the critical impact on children, and you'll be exploring diagnostic and screening. I hope that this deepening knowledge of harm will move us closer to implementing the necessary change to ensure domestic abuse is no longer minimised, so that protective frameworks can evolve, conversations can be had, and those protective frameworks can be implemented across our whole system in a way that's consistent. We see small examples of positive change. For example, allegations of parental alienation have historically been used to terrify survivors into silence, so they don't raise domestic abuse for fear of counter-allegations of parental alienation. Those counter-allegations had previously been dealt with inconsistently, with terrifying results for children who ran the risk of being removed from a protective parent if findings of parental alienation were made. The Family Justice Council has published some excellent guidance on how these cases should now be run. This is quite new guidance, only out last year. That guidance has been embraced, and some of the harm that had been done is now being slowly undone. I raise that specific area as it illustrates a dangerous example of how the system could be used to abuse, but also how children's voices could effectively be silenced. Because in most of those alienation cases, even where a child expressed a view, that view was disregarded on the basis that the child was considered to have been manipulated. So even where there was a mechanism to hear a child's voice, which, as we'll see later, are not in every case by a long stretch, the children were silenced on the basis that their voices meant nothing because they were thought to have been manipulated. Those children often had to wait until they were old enough to bring their own cases to be heard. This new guidance, recognises the dangers associated with the minimisation of domestic abuse and takes a step towards shutting down one mechanism used to silence survivors, and that's why I raise it here. And next slide, please. So the third issue I want to talk about, which I see as a barrier to an effective system, is the lack of transparency, consistency, and accountability for decision making. Our current siloed system allows poor practice to hide in the shadows and inconsistency and unfairness to prevail with little accountability. That's led to a postcode lottery of justice with variation in practice and decision making across the country. That, of course, undermines confidence in the system, increases anxiety amongst those needing to use the courts to keep them and their families safe. Will they be in a court with a judge who really understands domestic abuse and its nuanced presentation? Or will they be struggling to highlight harm against a feeling of minimisation as parental conflict? So there have been calls for greater transparency, and this is an area of significant and welcome change. Increased openness should help a flawed system to change by allowing us to look under the bonnet and call out poor practice. I've put up there on your slides the Transparency Project because that's the project promoting openness and accessibility whilst, of course, protecting anonymity, which is, of course, critical in family proceedings. Next slide, please. Now, the final problem I want to focus on is probably the most important, especially if we all agree that our shared vision for a family justice system, which allows families to thrive, requires one that enables children and family to participate in vital decisions about their lives. Our current system fails to hear children's voices. Research by the Nuffield Family Justice Observatory reveals that under the Child Arrangements Programme, just over half of children had opportunities to participate in proceedings in some way. Next slide, please. That finding comes from a study by Dr. Claire Hargraves and Dr. Linda Cusworth and their team from Lancaster University in 2024. That was published by the Nuffield Family Justice Observatory. They looked at what they call markers of participation, so Section 7 reports, Section 37 reports, or Rule 16.4 guardian appointments. And they found those markers were only present for just over half of the children in private law proceedings, which meant that just under half had no evidence of participation in proceedings concerning their whole futures. And interestingly, or perhaps surprisingly, that doesn't vary much with age. One might have thought that, oh, well, there's a lot of very young children whose voices might not have been heard properly because it was considered that they couldn't express a view, etc., etc. But no, these findings are almost across the board. Still less than 60% of children had a marker of participation aged 12, 13 and 14 when they could clearly express a view. Next slide, please. So many children for many years have suggested that we don't hear children well enough within our system and that their input comes too infrequently and often too late. Next slide, please. So Nuffield, again, I may be plugging them a little because I think it's an absolutely critical organisation, the only organisation to really be nailing the data in our family justice system and using it for that systemic change that I was talking about. They published a summary of the research relating to children's experience of private law proceedings. And they looked at 45 studies from 7 countries for research published over the last 20 years, from 2000 to 2020. And they found 6 key messages: that parental separation was distressing, traumatic and confusing, that good communication and access to information were important, that being heard and understood in court felt empowering, that being properly involved and consulted on in decision-making was important, that getting the right support makes a difference, and that thoughts and feelings on contact are complex and take time to process. Next slide, please. The importance of children's participation is the key to a fairer system. It makes the child more visible keeping them in the front of the court's decision-making. It improves the child's experience because they feel listened to. It supports parents in hearing their children, which can support early resolution. It upholds the right to involvement in decision-making provided for in the United Nations Convention on the Rights of the Child. It evidences the children's wishes and feelings, which is important for judicial decision-making. It gives the child the opportunity to ask the questions about what's happening. It helps the child understand what the court is and who's making the decisions. And it helps children understand how their views are used in decision-making. Well, there is some good news. She says with a bit of caution, of course. The Pathfinder project, now known as the Child Focus Courts, is a new model which goes some considerable way towards addressing many of the challenges that I've outlined. It's an increasingly widespread programme, now live across 10 out of the 43 court areas, all of Wales, Dorset, Bournemouth and Weymouth, West Midlands, Birmingham and Solihull, West Yorkshire, Central, Wolverhampton, Worcester, Stoke-on-Trent, Hampshire and the Isle of Wight. A national rollout is now planned. The next areas to start the model in this year are going to be Northumbria and North Durham, Cleveland and South Durham, Lancashire, Cumbria, York and North Yorkshire, Cheshire and Merseyside, Northamptonshire, Coventry and Warwickshire. Children's participation is central within improving children's experiences and appropriate participation in the court process as a key strategic objective of the model. And that participation is by default. So the expectation is that a child will be engaged with by the Cafcass Cymru, the local authority, as part of the child impact report prior to the first hearing, usually within 6 to 8 weeks of the application being made. Another great thing about Pathfinder is that domestic abuse is identified early in the process, and support processes are supposed to be engaged in order to build in that coordination at an early position. So the model places a greater focus on providing options for participation, for example, discussion with judges and other ways of involving children in the process at the same time as finding a mechanism to help screen and flush out dangerous behaviours or a dangerous dynamic within the child, the home that the child's been living in. Rolling out child-centred courts nationally could provide a real opportunity for bringing to life a new vision of a system which looks to solve problems and experiences and hears the voices of those involved, particularly children. So I'm super excited about child-focused courts. Judges involved in the pilots about them have spoken positively about the ability to make safer, more proportionate decisions without the need for repeated hearings, which of course re-traumatise and also we've just spotted aren't trauma-informed and therefore undermine the best evidence process. Cases were concluded months sooner, sparing children prolonged uncertainty and exposure to parental conflict. So on the face of it, this is all excellent. However, we need to explore how we're measuring success. It's not just about speed or resource savings. We need to understand the experiences of the people using the new system. How are they finding it? If we don't collaborate right now on a shared vision of good, we will really miss an opportunity with this new approach and more inquisitorial process for identifying children's voices and their wishes and feelings and participants' experiences. We need to make sure that this pocket of good practice is supported and allowed to shine, but that's not going to happen in a vacuum. The success of the pilots relied heavily on additional capacity, particularly from Cafcass, local authorities and specialist domestic abuse services. The model is more investigative and more collaborative, and that inevitably requires more time, skilled professionals and funding. We need better diagnostic tools and mechanisms to hear children's voices before court proceedings. We need accessible support networks and early and effective legal advice with well-trained, qualified lawyers to deliver it so that parents understand their options. Now, child-focused courts are just one example of a more inquisitorial child-centred initiative. Family drug and alcohol courts obviously being another one. And these problem-solving approaches signify a shift. But we need to do more than just approach cases differently. Much more work needs to be done upstream, and I know you're going to be talking about some of that today. Next slide, please. Sorry, there's a little feedback there, slide I missed, on the North Wales Pathfinder, which is, of course, very positive, particularly as you can see there that the children found in being involved at an early stage and their voices being heard to being key to success of that new model. Next slide, please. So, the Family Solutions Group have just put out a report calling for the creation of a commissioner for separated families to represent families in government consultations and to coordinate our fragmented policy and keep the welfare of children at the heart of provision. Currently, there's 4 million children growing up in separated families in the UK. And the report says that absent a coordinated policy and a public voice for separated families, we risk harm to children from escalating the parental conflict. I know you all know that. But I like this proposal of a commissioner for separated families to oversee private and not-for-profit services to promote consistency and a child-centred approach. The report says this: if we reshape our approach to truly putting children first, we can change the experience of separation for the next generation of children. The report highlights the potential of harm for defaulting to legal processes and adversarial language during separation and calls for legal professionals to adopt a more child-inclusive practice. So the message really is that when we're looking at building a system on the experiences of those using it, we need to focus not just on the family justice system when you get to court, which, as I've explained, is ill-equipped to deal with the sort of conflict in these complex cases. We need to focus on hearing children's voices before cases come to court and capturing those voices. Child-inclusive mediation provides an example of one way of doing this. It's promoted in the Putting Children First report, which appends the child-inclusive mediation protocol for solicitors to that report. It's really well worth a read. In child-inclusive mediation, a specialist trained mediator speaks directly with children where appropriate, so their views can inform parental decision-making. Importantly, it's not evidence for court. Mediators have to be trained and accredited in child-inclusive mediation to be able to speak to children as part of the mediation process. If they're not, they can work with an external child-inclusive mediator. The guidance is that children of 10 or more can be given the opportunity to speak with the mediator, but it's possible for mediators to speak with children younger where they consider it to be important and appropriate. Of course, both parents need to consent to child-inclusive mediation, and we have a problem that a lot of mediation is unsuitable in high conflict cases or cases where there's domestic abuse. The difficulty is our court system's also ill-equipped to properly look after those cases. So some of the diagnostic tools that you're discussing today and bridging that gap between identifying high conflict cases and domestic abusive cases is critically important, because knowing how to hear children's voices in those differing environments is key to getting a proper system that's built on the experiences of those using it. So, next slide, please. That's the link that you may need to the Family Solutions Group if you want to read their report in a little bit more detail. Next slide, please. So before I move on to any questions you might have, I'd like to just conclude by saying that our fragmented system, because of its siloed nature, has let children and survivors of domestic abuse down, and it does need systemic review. There's hope for systemic change by collectively gathering the data to make the case, to identify the broken bits of the system and to sort of zoom in and try and challenge them. And I see green shoots for systemic change coming through the child-focused courts and some of the other inquisitorial approaches we've got, which we're shoehorning into our largely adversarial system. So I think we do have the capacity to shift our rather stuck system so that it's better, but it's not going to happen without commitment and cooperation. So as you explore the complexity of our systems today, I'd urge you to hold in mind the part you individually might play in collaborating with others to support positive change and to reimagine a system which is built on the experiences of those using it. Thanks very much for listening.
Thanks, Jenny. I think Jenny's definitely on a mission. And I think we would all support Jenny on that mission to change a system that she describes as a system in trauma that actually, re-traumatizes those that are using it. It's been a really rare insight, I think, into a world that we don't understand particularly well. But I think after listening to Jenny, we have a much better understanding of the difficulties and the challenges that the family justice system currently face. I think everyone here and those that are listening online, and we've seen some of your comments and your thoughts, that's definitely been thought-provoking and inspiring. I think mostly because Jenny describes ways in which change can be hopeful and that there is hope for change, especially with people like Jenny trying to drive that. Especially, I think what's important is those child-focused courts as well. It'd be interesting to see what difference they make for children, in the future. Just in terms of questions, we have 3 questions that we would like to put to you, Jenny. However, if it's okay, due to the time schedule that we're on at the moment, we need to stick to time, we've been told. If it's okay, can we put those questions to you and we'll send out your answers, if that's okay, in the post-conference communication, if that's all right?
Absolutely, that's perfect.
Thank you so much. That was fabulous.
Enjoy the rest of your day. Thank you for inviting me.